Brian Winchester.
Right, and Mr. Winchester testified that Ms. Williams knew that he was going to be hunting with the victim, correct?
Correct.
And so when Mr. Williams didn't return home, did the victim ever call Mr. Winchester that day?
Well, no, she never called Winchester. I think she did call around. But
The person that he was purportedly duck hunting with that very morning.
Correct. So she never calls Brian Winchester, and I think at one point when she's asked by law enforcement, she even says, well, go talk to Brian. He was hunting with Brian. So, I mean, she clearly knew where he was, and I think the jury could make the inference based on Brian Winchester's testimony that there is no way Mike Williams showed up on that duck hunting trip without speaking to this defendant and getting her approval.
Well, how do you get to that point? Because the evidence shows, or the testimony shows, 1 week it's canceled because she tells the victim not to go. The next week, it could easily follow that she just didn't say anything to him about not going that next week. So is the state's position then that the verbal act, so to speak, was her failure to tell him not to go on that day to the hunting trip, knowing that he was going to go and get murdered?
Well, no, my argument is there's a fair inference from the record that the victim had a conversation with her and that he either got her tacit approval, or not tacit, I guess, her explicit approval, or she gave him permission to go. But I mean, it's their anniversary and they have a trip planned.
And
there is no way they didn't have a conversation.
Wasn't there also testimony by Mr. Winchester that there were numerous conversations between December 9th and 16th between the defendant and Mr. Winchester regarding firming up plans for the murder to occur on the 16th?
That's correct, Your Honor.
And he did, in fact, show up on the 16th to go duck hunting?
He did, and he said the plan was the same, so presumably this defendant's involvement is the same if it's the same plan, which is make sure he shows up.
So coming back then to the first question, which is, so what is it? What were the words, or what did Ms. Williams say to, if it's not based on an act, it's based on words, what is it that she did or said?
I can't quote Ms. Williams because, it's not in the record exactly what her words are.
Well, what did Mr. Winchester say that she said to get Mr. Williams to go on this hunting trip? Or otherwise, what did Mr. Winchester testify to that Ms. Williams said to assist this offense to happen?
What he said was they agreed on a specific plan, that her involvement, other than alibis, was to make sure that he went, that they reaffirmed that agreement after she canceled the first time, which presumably means her involvement is the same, and then he shows up on the day in question, the day of the murder, and that later when this defendant's questioned by law enforcement, she says to the effect of, well, go talk to Brian. He was hunting with Brian.
Just for purposes of my question, assuming that we disagree with you on that point, is there any other evidence in the record that she verbally acted or physically acted in some way to facilitate the crime?
Yes, and that actually was not my primary argument of what her physical act was. So in my brief, my first argument was actually that so Brian Winchester testified about the life insurance policies and how first he's got a $250,000 policy, a $500,000 policy, and shortly before his death, he gets $1 million life insurance policy. And Winchester describes this conversation he has with the victim, where the victim makes clear that he wants the $500,000 policy to lapse. He wants the $1 million policy to replace it. And he uses these exact words that I'm about to say. Behind his back, she paid the $500,000 premium to keep it open, which extended the window of opportunity to kill him under the motive of she wants the life insurance money. Her writing a check, that's a physical act. She wrote a check without him knowing about it to keep that policy open. And Winchester was very specific in saying that not only was it behind his back, but he was worried that they could only get away with doing it once before the victim found out what they were doing. So that was actually my first argument for what the physical act was.
And when did the defendant first make a claim on that policy?
19 days after, it was January 4th, 2001. So 19 days after the victim's disappearance.
And was that a time when people were still searching for the victim?
Yes, it was.
So wouldn't that act, though, wouldn't that matter more if this were an insurance fraud case as opposed to a murder case? I mean, the fact that she wrote a check for a premium, that indicates the intent part of aiding and abetting.
Well,
How does the insurance policy premium facilitate the murder of Mr. Winchester?
because the state's theory of the case as to the defendant was that her motive was obviously she wanted to be with Brian Winchester. They're having this affair for years beforehand. She doesn't want a divorce because she doesn't want to share custody, or at least in part doesn't want to share custody. So that's part of the motive. And the other part of the motive was she wants the life insurance money. And Judge Tannenbaum, to I guess better illustrate that point, Brian Winchester also testified as to the $1 million life insurance policy that the victim got that policy, I think it was, according to Winchester, 6 months to a year before the murder occurred. And that he also said that him and this defendant started planning the murder, it was a year to a year and a half before the murder. So based on those timeframes that I just told you, this defendant was encouraging the victim to take out a $1 million policy while she was simultaneously planning his murder. I guess illustrates the point that that's an act in furtherance of it.
An act in furtherance.
It's an
of
act
what?
in furtherance of wanting to murder him. It's an act.
Well, she's not charged and wasn't convicted of wanting to murder him.
Well,
she was convicted of being a principal to murder.
Right, but part of that is she has to intend for the murder to occur.
Sure.
And the defense is saying she has to commit an act in furtherance of the murder. And if her motive, in part, was the life insurance money, when she's writing checks behind the victim's back to keep the policy open, when she's encouraging the victim to take out more life insurance while she is simultaneously planning his demise, those are acts in furtherance of the murder.
Isn't that sounds more like an argument in favor of conspiracy to murder? If the conspiracy, the furtherance idea, if we don't have an overt act requirement in Florida for a conspiracy, and it sounds like you're merging on the principal charge, you're merging the intent and the actus reus, or the actual thing that she did to facilitate the crime.
Well, my larger position is that you don't need to commit an act at all under principal theory.
Sure. Or say,
say
something to encourage it.
Right.
To
So
happen.
so we're talking about an alternative argument that even if you were to hold that an act is required, this would qualify as an act. And I guess to analogize, me and the defense, we disagreed on how we read this court's decision in Banks from 1991. So Banks was the case where the defendant was charged, I think it was sexual battery, and he procures witnesses to give him a false alibi. So on top of the sexual battery charge, the state then charges him with being a principal to the perjury. And the theory is he procured these witnesses to provide false alibis, and that when they went through their depositions, they actually did lie. And the disagreement comes from the fact that he not only procured them to lie, but he actually wrote out a script for them. And the way the defense is asserting that this court should read Banks is that he committed a physical act by writing out a script and then calling the witnesses and coaching them prior to their depositions. And if they're correct and that's an act, what I'm saying is this defendant writing a check is no different than the defendant in Banks writing out a script. So my first position is you don't need an act at all. But even if you need an act, her writing a check and paying this policy behind the victim's back is the physical act that would be in furtherance of the crime.
Well, could the murder have been committed but for the renewal of the life insurance?
I'm not quite sure.
In other words, that wasn't necessary. The renewal of the life insurance isn't causally related to the murder, is it? Or if
It's
it
not
is,
physically
explain to me how it
necessary.
is.
I'm sorry, I didn't mean to cut you off. It's
Yeah.
not physically necessary, but and this is where the devil is in the details with Brian Winchester's testimony. He's talking about the window of opportunity, and there's two primary concerns going on with their window of opportunity. One is this has to occur during duck hunting season. Duck hunting season isn't very long, and even within duck hunting season, he explained, you can't just go any day you want. So one concern is duck hunting season. The other concern, and he was very specific, is they needed to do this before the policy lapsed. And that's where it comes into play that behind this victim's back, she paid to keep the $500,000 policy alive, which extends the window of opportunity that Brian Winchester was talking about. So while it's not physically a requirement to commit the murder. It's extending the window of opportunity that was a concern to them. So I guess in a way, it kind of, based on the motive, it kind of was necessary for one of their concerns. And then the final point I just want to briefly address is the closing argument. I did make an argument that it was invited. I stand by that, but for purposes of oral argument today, I want to address the fundamental error aspect of it. And it's not fundamental. First, all of the cases that the defense cites, none of them have found a comment on a defendant's off-the-stand demeanor to be fundamental. So for instance, someone talked about the Pope case where the defendants grinned from ear to ear. That wasn't found to be fundamental error. There's another case in which the prosecutor commented, so it's Rodriguez, where the prosecutor commented on the fact that the defendant was sleeping in front of the jury. That one was actually preserved and still not found to be reversible. The only one of the cases that the defense cites that actually resulted in a reversal was Baldez, where the prosecutor commented on the fact that the defendant was glaring at a witness. That was a preserved objection. So none of the cases they rely on have found such a comment to be fundamental. And in this case, it's not fundamental because this isn't the first time that the jury heard about this defendant's demeanor. So this was a 3-day trial, and throughout the course of the 3-day trial, the jury repeatedly heard about how this defendant's demeanor throughout this whole process was inappropriate for someone who's a grieving widow. Just very quickly, I picked out 4 examples of throughout this trial where the jury heard such evidence. So for instance, Cheryl and Nick Williams both testified to 2 encounters that they had with Miss Williams. And in both of those encounters, she was angry and she threatened Miss Williams and Mr. Williams that if they don't stop this investigation, they're not going to see their granddaughter or their niece again. And one of those is 5 months or 6 to 9 months after the disappearance. The other one is 5 years after the disappearance. Years later, there's then this recorded phone call with Kathy Thomas in which Ms. Thomas twice accuses this defendant of murder, and she doesn't react in anger, despite the fact that she's just been accused of murder twice. And in fact, when she's asked, why couldn't you all just get a divorce, she actually answers the question, very interestingly, and I would argue it's a tacit admission, but she answers the question and essentially says, I couldn't do anything with the divorce, was her answer. And then she starts talking about she would have had to get lawyers and all this stuff. So the bottom line is this is not the first time the jury was introduced to the idea that this defendant's demeanor was inappropriate.
But doesn't that point undercut your argument that this was invited error? What couldn't it have been that the defense counsel was commenting at closing about that aspect, that testimony about demeanor, as opposed to demeanor in court?
You're talking about her demeanor before trial?
Right.
No, well, if he had stopped, so I actually have the exact wording. If he had stopped at, it's not a case about how people mourn, it's not a case about how people grieve. If he had stopped right there, I would fully agree that he's referring to her out-of-court demeanor. But he then takes it farther and says, it's not a case about whether people sit there and stare. And that's clearly a reference to what's happening in the courtroom. And it was a strategic decision made because everybody knew the jury was staring at Miss Williams and knew that was staring at her inappropriate demeanor throughout this trial. So I think that statement is what pushes it over the edge from we're talking about out of court to now we're talking about very specifically she is sitting in court stone-faced. So I disagree that that's a general comment. That was something very specific, and for that reason I think it was invited.
Thank you, counsel.
Okay, thank you.
Appreciate it. Madam Clerk, if you would add 2 minutes and 40 seconds to the appellant's rebuttal time.
If I could address briefly counsel's comment about DiGiulio. I agree that this was before the harmless error standard in DiGiulio, but the court used the term reversible error to mean not just error, but an error that requires a reversal. That's what they meant. Before we had the harmless error standard and the burden on the opposing party, the appellant had the burden of showing reversible error. And the Supreme Court of Florida is describing this as reversible error, meaning There's no other way around it. And if you think about it for a minute, there couldn't be any other way around it. If you want to say that just vacating one of the convictions clears it up, then you may as well just abandon this whole remedy about compelling an election. What would the point of it be if you could fix it later? If you could take two charges, one a capital felony punishable by life without parole, and another one, and let them put them both in front of the jury, and then later on, if they get convicted of both, pick the one that they want to vacate. It doesn't make any sense. It would completely undercut the remedy. So I know these cases are old. I've conceded that. But they've not been reversed. And I think the court has an obligation. And by the way, while we're on the subject, I think that on the Bazemore case, Judge Altenburn in that case actually made a suggestion that this problem could be cured by giving the jury an instruction. In other words, if you didn't force them to make a choice, you could actually instruct the jury, these are inconsistent, you can only pick one or the other. I actually suggested that to Judge Hankinson. I would have been happy with that, because maybe the jury would have picked accessory. But he didn't do that. He sent them both back. Mr. Fuchs argued for a conviction on both, and he got a conviction on both. So I think that is, in the language of the case law from the 40s and 50s, reversible error. In the language of today, not harmless error. Let me say a thing or two about this insurance policy, the business about paying the premium on the insurance policy. This is an argument that was made about 10 times in the appellee's brief. And it is the first place where the argument was ever made. Nobody in the trial court ever thought that this was an act. I asked Investigator Devaney, the chief investigator for the state, if the defendant, quote, took any action in furtherance of the plan, if she committed any overt act to make that happen. And Investigator Devaney answered, an overt act? No, sir. When the state started out with the theory that helping or making sure that he went hunting was the act, that was what they argued at the judgment of acquittal argument. And when it became clear to them that there was actually no evidence that she did that, they said, oh, well, it's a verbal act. But here's the problem. What was the verbal act? I think you've identified this problem in your questioning. Whether we get beyond this debate about whether you need a physical act or a verbal act, there is still nothing that the defendant did or said that helps the Winchester in the actual commission of the crime.
Well, currently our standard is we're also supposed to consider all reasonable inferences from the evidence in favor of the state, and the state points out that clearly she had veto power over the first trip. So can the jury not reasonably infer that she did not undertake that veto power or affirmatively allowed him to go on their anniversary on the hunting trip?
Well, first of all, I don't know whether allowing a person to go hunting, we don't know whether he was otherwise planning to go hunting or inclined to go hunting. I don't know how that is an act, that necessarily an act.
Well, don't we have Mr. Winchester's testimony to that effect?
He testified that that was her role, and he testified on the first trip on December 9th, she stopped him from going hunting. I think the only inference you could really draw, maybe, is that she had the power to stop him. But we're really getting pretty far afield with this. First of all, to say that they're going to rely on an inference, that's pretty much a confession that they don't have any evidence, isn't it? I mean, they're relying on an inference. And I think they're asking you to make that inference do a whole lot of work, a whole lot more work than it should.
Well, counsel, how specific do you assert the words need to be? Did Winchester need to testify that, okay, to the defendant, you'll get Mike to the hunting trip? And was it necessary for him to say, and she said, okay, I will? Is that would that be enough?
I think the problem here is, you mean if there was evidence she said that on the day of or something like that?
If let's say 2 days before the murder, this is a hypothetical, Winchester said, okay, you'll get him to go duck hunting on Saturday, and she said, okay. I will make it happen.
Well, first of all, she didn't say that. But
I understand
she didn't say
hypothetical.
that. But just to take your example, That would be, I think, if anything, would be evidence that goes to planning the crime. Planning a crime is a crime. I'm not arguing that. Covering up a crime is a crime. I'm not arguing that. What I am arguing is that there is no evidence of assisting in the commission of this crime. And that's important. So if she told him a week before or 2 days before, yeah, I'll get that done, I don't know how that can be how you could possibly characterize that as something that she said that actually assisted him in the actual commission of the crime, because we don't know that she did that. And frankly, the inference that she did that is contrary to the direct evidence that we have in the case. The direct evidence we have in the case is that they didn't have any contact with each other. When I say they, I mean Brian and Denise didn't have any contact with each other for a couple of days before December 16th. That the trip on the 16th was planned entirely by Brian. That's in the record. He called Mike. He told Mike where to go. He told Mike where they would meet. They agreed that there's no evidence that Denise had anything whatsoever to do with that. So we're going to sit here and convict her. The state is asking you to sit here to affirm her conviction based on the fact that, well, maybe she let him go hunting that day.
Are you making a distinction between participation in planning an offense and doing something in furtherance of that plan?
Yes, I absolutely am. That's right.
And what is the basis of that distinction?
Well, I don't think you're guilty of committing a crime just because you had knowledge it was going to be committed.
Well, that's different. I mean, having knowledge of it is different.
Or that you planned it. Or that you planned it. Planning could be solicitation or conspiracy, but it's not the commission of the actual offense. I mean, I think what that does, what that could show, and what the jury was entitled to infer from that, is that she knew and that maybe she had the intent. But remember from Ammons, you have to not only have an intent, you have to actually do something that helps in the commission of the crime. And here the state doesn't have anything to show that she did or said anything in the commission of the crime. Let me just make one other comment very quickly. Brian Winchester testified that he never even told Denise that he had shot Mike. So, I mean, it's pretty hard to understand how you could say she was a principal to a crime. She never had any verification. She didn't go. She wasn't there, and never even had any verification that the crime had been committed. Thank you.
Counsel. Thank you to both attorneys for excellent presentations. The court stands adjourned.
All rise.